Brenda, Croeso, welcome to Communities Creating Homes Network event. And today we're going to be talking with Simon White of the Welsh Government about the Renting Homes Wales Act. Simon will be talking more about it in detail, but just to give you some context and background, this is a new piece of legislation and it is affecting landlords, all types of landlords in Wales, and it's specifically going to mean some changes for people who are working in the community-led housing network, the community-led housing movement, including housing co-ops. So I know some of you are in housing co-ops already today, and some of you are not, but this legislation is relevant to everybody. But if you're in an existing housing co-op, then you will have to change what you're doing. Previously, it's not been the law, a legal requirement to have short tenancies for housing co-ops, and it's been more like having occupancy agreements or something like that, and it's bespoke to each housing co-op. And this piece of legislation will change that, so there's some work to do around that, things to get used to. But in conversations that we've had previously with Simon, that isn't going to change the ethos of housing co-ops or what we do as groups, and it's not going to replace the secondary rules that you have or the primary rules, the rules that you're kind of working with and have signed up to. There will be some adjustments, changing, moving over from those occupancy agreements and what I had previously. And this will take a bit of time to have a look through and get used to, and there is a timetable to this that starts in July this year, from which point all landlords in Wales will be expected to offer the new contracts, standard occupation contracts, and then for existing members, for existing tenants, that process will have to be completed within 6 months of the July time. So yeah, we've got some work as Wales, as a Compass, formerly the Wales Co-op Centre, to support housing co-ops in this process. And please be back to us about that after Simon's done his presentation and answered your Q&A. So without further ado, Simon, please do take the floor and tell us about it. Thank you.
Thank you very much, Alan. Thank you. So yeah, really good to be here today, and looking forward to the questions, and I'm sure we'll have some good discussions. I'm going to take you through a presentation giving you an overview. It may answer some of your questions, but obviously we should have plenty of time to cover questions as well. So I will just share my screen, and hopefully that will all work well. Let me just. Can you all see that screen now? Hopefully you can. So, so that's me, Simon White, Head of Housing Legislation within the Housing Policy Division. Those are our contact details there. That's the web address as well, where you'll find all the sort of introductory information and then lots of guidance and various documentation that I'll be referring to today. So I will just take us through the slides. So brief summary, renting homes is based very closely on recommendations that the Law Commission came up with back in 2006, which is a long time ago, but they were very radical reforms then, and they are still radical reforms now. Essentially, housing law, as I'm sure many of you have had bitter experience of, is a very complicated area of law. And that's why the Law Commission felt that there needed to be a radical overhaul. We weren't able to take action, although there was broad support for the recommendations in Wales at the time. We weren't able to take action back in 2006 because Wales didn't have the necessary powers under the devolution settlement then. But post the devolution referendum, which I think was it 2010 or 2011, we then got the necessary powers. And therefore we're able to press ahead with implementation. So we brought forward the Renting Homes Wales Act that got royal assent back in 2016. So yeah, that's again quite a long time ago. We always knew it was going to take a long time to implement the legislation because it's very complicated. Well, I won't say it's complicated, but there was a lot of secondary legislation that we needed to make, where some of which I'll be referring to, and that needed to be developed and consulted on and so on. And then we were back on the course to sort of implement, and then when Mark Drakeford was elected as First Minister, he made a commitment to improve security in the private rented sector. And so we took the decision, rather to implement the 2016 Act as it was, which was still included things like a 2-month no-fault notice period, the equivalent of Section 21, which some of you may be aware of at the moment. Rather than implement and then come back and change it very quickly, we decided to amend the 2016 Act, pardon me, and we did that last year through the Renting Homes Amendment Act, and so that is now what we are implementing. So overall, what does this do? Well, it will create a single legal framework for social and private renting. So at the moment, there are lots of different types of tenancy out there, and people's rights will differ according to who their landlord is, frankly, whether or not it's a local authority or a housing association. Very different rights associated with those two types of tenancy, or whether in the private rented sector. So one of the things that will be achieved through renting homes is that there will be a single social tenancy. So anyone who's a tenant of either a local authority or a registered social landlord, they will have essentially the same rights, and they don't have that similarity or consistency of rights at the moment. One of the other big changes is just making sure everyone gets a written contract. At the moment, that's not the case in the private rented sector in particular. So renting homes, because it's all about getting clarity on rights and responsibilities, and everything is in the contract, so everyone has to have a written contract. So we've made model contracts available, and we'll probably talk about those later, because I know there was some interest in one of the questions that came in advance of the session about a sort of model contract. And there are two types of contract in the scheme. There's a secure contract, which is essentially replacing the secure tenancy that local authorities issue, the assured tenancy that registered social landlords issue. It can be used by private landlords as well. So there's that secure contract, and then there's what we call a standard contract, which is basically similar to the current assured short hold tenancy. It can be fixed term, or it can be what's called periodic, which basically means it runs from week to week or month to month. And another significant change is the Act has then introduced a legal basis for supported housing, supported accommodation as well. Probably not so relevant to today's discussion, but we can pick up any questions on that later. So some key features of the Act as it was passed back in 2016. It introduces what's called a fitness for human habitation obligation on landlords. So the home has to be fit to live in, basically. And just to give you an explanation of what fitness means and how it's different from the current repairing obligation, which also continues. You could have a boiler in a property that works perfectly fine. It's not in a state of disrepair, but it's a 4-bedroom property and it's a teeny tiny boiler. It's not suitable for the property because it won't be able to heat the property. So that's an example of something that would probably be in breach of the fitness for human habitation requirement. We also address retaliatory eviction, which is something, again, a few private landlords, you occasionally hear of this. The tenant complains about the boiler needing a repair, and the next day the landlord issues an eviction notice. So basically we address that within the 2016 Act. I'll say more about that later. There are more flexible arrangements for joint contracts. What that means is you can add and subtract someone to the contract without having to end one contract and start another. Because at the moment, if you've got a joint contract and one person gives notice to leave, that will end the tenancy for everyone living in the property, and that can end up with sort of unintentional homelessness situations. So basically, the new scheme is much more flexible for people to join and leave the contract. There's increased notice period for a rent increase, so that goes up from 1 month to 2 months. There's no mandatory ground for eviction for serious rent arrears in the secure contract, but there is in the standard contract. Enhanced succession rights basically means people, if the tenant or contract holder, as we call them, dies, then that determines who they can pass the contract on to. And there are slightly improved succession rights under renting homes compared to current arrangements. It's easier to repossess an abandoned dwelling. So if the tenant has deserted the property, the landlord can get back possession without needing to go to court, which can take many months. So it's easier to get possession in those circumstances. And as I said, there's a tenure specific to supported accommodation. Then, as I said, we made some amendments to the 2016 Act last year, and that was all about improving security of tenure. So what we did is basically, this, under the 2016 Act, we had preserved the current two-month no-fault notice arrangement. We extended that 2-month period to 6 months. So basically, if the tenant, the contract holder, is not at fault, then they will be entitled to 6 months notice if the landlord wants to get back repossession. You can't issue that notice during the first 6 months of occupation. So essentially, there's a minimum 1 year of occupation within the arrangements. We also made some. We also sort of tightened up the arrangements around retaliatory eviction to make a sort of further disincentive around that. And we also had to make changes to how fixed terms work, basically so that a landlord couldn't give give short fixed term contracts in order to overcome the increased security of tenure policy that we were putting in place. And the same was true of break clauses. So just to give you an overview of some of the key concepts in the legislation, I've already started talking about an occupation contract. So at the moment, anyone who rents a home in Wales, they will do so either under a tenancy or a license. So that's like the bedrock of how someone occupies a property, a tenancy or a license. Under renting homes, that will still be the case. You will still have tenants and licensees, if you like, that they will still be the bedrock of how someone occupies a property. But if, regardless of whether they're a tenant or a licensee, if they rent their home, so they pay rent to occupy a dwelling as a home, then it will be an occupation contract. So the reason the Law Commission did this was basically, at the moment, landlords can sometimes say, we're giving you a license, not a tenancy. And they think that gives them more control over the property. They can evict more easily. In law, under case law, what actually the law actually says, if it looks like a tenancy, it acts like a tenancy, it's a tenancy. It doesn't matter what's on the piece of paper. So the Law Commission sort of simplified this by saying that it doesn't matter whether it's a tenancy or a license. If it's to occupy a dwelling as a home in return for rent, it's an occupation contract. And that's also why we talk about contract holders rather than tenants or licensees, because they are contract holders, whether it's they are a tenant who's a contract holder or a licensee who's a contract holder. So two types of occupation contract. As I said earlier, there's that secure contract, which is periodic, sort of week to week, month to month. And then there's the standard contract, which can be either periodic or fixed term. And then under the Act, there are two types of landlord. And there are community landlords, which is essentially local authorities and registered social landlords. So housing associations would generally be if they're a registered social landlord. Fully mutual housing associations are not community landlords. So when we talk later about how this applies to the sort of cooperative housing, if it's a fully mutual housing association, it's not a community landlord. So community landlords, local authorities, and RSLs. Everybody else is counted as a private landlord under the Act. So often say, Welsh Government, if we, as we sometimes do, we're doing a road scheme, we buy a property that's going to have to be demolished for the road scheme, but it's not going to be, the road's not going to be built for 2 or 3 years, we might rent that property out on a temporary basis. If we do that, we will be doing that in future as a private landlord. So basically you've got community landlords and everyone else is deemed a private landlord. And then the Act also sets up some default arrangements. So if you're a community landlord and you let someone move into your property and you don't do anything else, they will have a secure contract. That's the default arrangement. If you're a private landlord, the default is the standard contract. So that's a bit how the law works at the moment with private rented sector. If a tenant moves in, the default is it's an assured short hold tenancy. So variations to those defaults are possible. So social landlords can issue short-term standard contracts for certain things. And as I said earlier, private landlords can issue a secure contract if they want to do so. And then we also talk within the legislation about the written statement. And this is essentially, it just recognises that the contract can start, as it can at the moment, it can start verbally. So if a private landlord lets someone move into their property now, it can operate entirely as a verbal contract. They're not actually required to issue a written contract. So under renting homes, you can still start the contract verbally, but within 14 days of the person moving in, you have to issue a written statement of that contract. So it's the written statement, it's essentially the same as the tenancy agreement. So it's that written document that underpins the occupation. So for new people, for a new person moving into the property, they have to be given that contract within 14 days, that written contract within 14 days of the date they moved in. You can issue the contract in advance. So you can actually agree the contract before the person moves in, that's all fine. And essentially this is all about making sure, as I said earlier, that the landlord and the contract holder both have a written statement of what the rights and responsibilities are, so that everyone's clear. Because in future, if there is going to be an eviction or the tenant wants to make a claim for repair against the landlord or something like that, everything is based on what's in the written statement of the contract. So that's the importance of why everyone has to have one. So that means there are also some sort of penalties if the landlord doesn't issue the written statement. So if they don't issue it within 14 days of the person moving in, the person occupying can start withholding rent, a day's rent up to 2 months' rent until they get that written statement of the contract. But I'm sure in all of your cases, you would be issuing contracts before people move in, so it's probably never going to be an issue. So what are the terms that are in the contract? So there are 4 types of term. There's what we call fundamental terms, and they're set out in primary legislation. They're the most important sort of rights and responsibilities. So they include things like that fitness for human habitation requirement, the repairing obligations, the antisocial behaviour term. All of those are fundamental terms, and and then you have the next set of terms, which are supplementary terms, and they deal with more day-to-day things. And so an example of a supplementary term would be that the contract holder has to give notice if they're going to be absent for more than 28 days from the property, because that could have an impact on insurance potentially, or other matters. So there are then terms relating to key matters. So those are just things like the name and address and the amount of rent and those sorts of things. And then there's just additional terms. So additional terms are anything else that is appropriate to your contract. And there may well be specific things that you want to include from a cooperative housing perspective that would feature in the contract as additional terms. So if the contract has to include everything in it, whether it's fundamental, supplementary, or additional. The actual final terms will depend a bit as to whether or not it's a secure contract or a standard contract, but actually 90% of the terms are probably going to be the same across all of those types of contract. And what that means is, over time, if people are moving from one rented accommodation to another, the actual contract they get is going to look very similar. So over time, both landlords and contract holders will get a much better understanding of the rights and responsibilities, because there will be much more consistency. So one point to flag is I've talked about fundamental and supplementary terms. One of the key difference to note here is fundamental terms some of them can be varied, some of them can't. But so the antisocial behaviour term, for example, that cannot be varied. It has to appear as set out in the primary legislation. But other fundamental terms can be varied. So, for example, if you take the 6-month no fault notice period, it would be quite possible to agree that a 9-month no fault notice period, but you couldn't agree less than 6 months. So that you can vary those types of fundamental terms only to benefit the contract holder, not the landlord. Whereas supplementary terms, they can be varied either to benefit the landlord or the contract holder. So recognizing that it's quite complicated, what are the fundamental terms to which type of contract? We have actually set out model written statements of contract, and they're available on our website. And we'll talk about them more later. So I talked about that fitness for human habitation obligation. So that's a new thing. So it's probably worth sort of explaining that a bit more. So at the moment in housing law, there's something called the Housing Health and Safety Rating System, HHSRS, which basically is the system that local authorities use. If they go in to do an inspection in a property, they assess the property against 29 hazards. And those hazards are things like risk of electric shock, risk of slips or trips. It would be also excess mold, those sorts of issues. So those 29 hazards also form the basis of our fitness for human habitation obligation. So the landlord basically has to look at the property and say, okay, looking against those 29 hazards, do I think the property is fit for human habitation? And we've set out guidance on that, and the details are set out in regulations, and again, available on the website. In the regulations, in addition to the 29 hazards, we've also listed 3 specific things that have to be present in a property for it to be fit for human habitation. And those things are, there has to be a hardwired smoke detector, and there has to be an electrical safety test done at least every 5 years, and there has to be a carbon monoxide detector present in any room with a gas or solid fuel appliance. So those are the 3 specific requirements on top of those 29 hazards. And if any of those 3 things are missing, then the property would be deemed unfit. There is a grace period on fitness, but only in relation to the electrical safety testing and the hardwired smoke detectors. So we've allowed 1 year after the date of implementation to get any hardwired smoke detectors fitted or to get any electrical safety testing done, because recognize that may involve some works. So one of the key elements is obviously you've got your contract in place. How can it be ended? What are the possession arrangements? So the general arrangements are for all contracts, there's a breach of contract ground. So going back to what I said earlier, everything is in the contract. So in future, there won't be, as there are at the moment, sort of schedules of grounds tucked away at the back of a housing act. Everything is in the contract. So there is therefore a breach of contract ground. So if you breach the contract, the landlord can apply for possession on a breach of contract. It's a discretionary ground, so the court doesn't have to make the possession order, and there's some guidance as to whether or not it's reasonable for the court to make the possession order, but that's what's called a discretionary ground. There are then what are called estate management grounds, probably less likely to be relevant to yourselves, but they're things that if you were going to refurbish a block of flats and you needed to move people to allow that to happen, then you could use one of the estate management grounds. Again, it's discretionary, and you do have to make suitable alternative accommodation available in that situation. So now looking at secure contracts, in addition to what I've just talked about, there's also the ability for the contract holder to end the contract by giving notice to the landlord. So if they do that, and it's a 4-week notice, then they don't move out after that 4-week notice has expired, then the landlord can apply to the court for possession. So that, and I should apologise. I know I'm talking about tenants and landlords, and that terminology is not sort of necessarily the right terminology for the cooperative housing sector, but it's how the legislation is drafted, but it will still apply in the same way to the sector. So so if the person occupying gives notice to say they're going to leave, but they don't move out because the landlord might have made arrangements for someone else to occupy, that's a ground on which the landlord can go to court, and the court has to make the possession order in those circumstances. But as a secure contract holder, that's it, that the landlord wouldn't have any further rights to evict someone. So moving on then to the periodic standard contract. So in addition to what I've just talked about, there is then the no fault notice. So this is this arrangement where the landlord is able to give notice and say, look, we just want to end this contract. And at the moment, under current law, that's a 2-month notice. There's a lot of concern, as you're probably aware of, that 2 months is not enough for someone to go and find somewhere else to live. So that is really what we've said. The principle we've said is, if you're not at fault, you should have at least 6 months to find somewhere else to live. And that's what we've done within that change to increase security of tenure. You may have seen other parts of Scotland, for example, did away with what their equivalent of the no fault ground, but they then had to introduce other grounds, because landlords will always need to be able to get possession back if they want to live in the property themselves, or they want to sell the property, that sort of thing. So there, even though the tenant is not at fault, so you can't actually abolish no fault grounds, because there will always need to be some ability for the landlord to get back possession, even if the tenant isn't at fault. So under renting homes, we've said 6 months notice, and you can't serve that notice during the first 6 months. So essentially, someone has that minimum 1-year occupation right. There are also some situations where you can't serve a no fault notice. So that's if you haven't protected the tenancy deposit, or you haven't issued there's a requirement to issue an energy performance certificate. If that hasn't been issued and it should have been, then you can't issue a no fault notice. So there are those sorts of restrictions on the no fault notice, as there are in current law. But if all the boxes are ticked and it's all done properly, the court has to make the possession order. It's called a mandatory ground or an absolute ground. But as I said, there is this exception, which is retaliatory evictions. So what this means is, I said, if the tenant, if everything is going along smoothly, and then the tenant complains that the boiler needs repairing, and the landlord decides, actually, no, I don't want to do that. I just want to get someone in who's not going to complain, and I'm going to issue you a no fault notice. What the tenant could do in that situation is provide that evidence to the court and say, look, I complained about the boiler repair one day, I got the no fault notice the next day to evict me. The court in that situation could weigh up the evidence, and they could decide not to make the possession order. They could say, we think you were acting to try and avoid your responsibilities as a landlord. And what we're really trying to do there is just sort of stop landlords thinking they can automatically get possession in that sort of situation, to try and stop that retaliatory eviction practice. I did say there is this serious rent arrears ground on the standard contract. So that's if the contract holder is more than 8 weeks or 2 months in rent arrears, that is a mandatory ground. Again, the court would have to make the possession order if that was established to be the case. Fixed term contracts, One of the changes we made to fixed terms at the moment, if someone had a fixed term assured short hold tenancy, then the landlord can serve a notice during the fixed term that basically says, and this contract is definitely ending at the end of the fixed term. And if the person stays in occupation, the landlord can go to court to get a possession order immediately after the end of the fixed term. Under renting homes, because we wanted to make sure there was this increased security of tenure, basically what happens is at the end of the fixed term, you can still have fixed terms, but at the end of the fixed term, if the person stays in occupation, then a periodic contract comes into place. And under the periodic contract, the landlord would have to serve the 6 months notice, assuming that the tenant wasn't at fault in any way. So there is likely to be a change to how fixed terms operate, but that will be a sort of an adjustment in the system, if you like. There is also the serious rent arrears ground as well in the fixed term contract, of course. So I talked about abandonment. So just say a bit more about this. So this allows landlords to get back possession if without needing to go to court. So what happens is the landlord essentially gives a notice to the contract holder, which requires them to tell the landlord within 4 weeks if they haven't abandoned the dwelling. And you could give that notice at the property, at a work address, any address you know, basically, of the person living in the property. During that 4 weeks, the landlord must satisfy themselves by making inquiries as to whether or not they are absolutely happy the property has been abandoned. If they remain happy that it's been abandoned, they can issue a further notice and get back possession at that point. So basically, that saves that sort of the months and months that you might end up otherwise having to go to court to get a possession order, even though you know the person has actually abandoned the property. So it enables property to be used more efficiently, really. You don't have property standing empty for no reason. There have to be some safeguards to that. So if within 6 months the contract holder wants to contest it, they can go to court, and the court can make any order it thinks fit. So it's basically only use the abandonment procedure if you're certain the tenant has abandoned the property. Then joint contracts. So as I said, more flexibility. So at the moment, if you've got, say, a couple living together on a joint contract, joint tenancy, and there's a relationship breakdown situation, one partner leaves, they go and maybe make a housing benefit claim on another property. To make that housing benefit claim, they have to end the current tenancy, and that then, of course, ends the tenancy if the person's still left in that property, and that can leave them homeless potentially. So under renting homes, that won't be the case. You sort of, as I said, you can add and subtract people to the tenancy or from the tenancy, from the contract, without having to stop and restart again. So we've made model contracts available. As I've said before, they're on the website. You are able to produce your own. They will look a lot like our models because they are going to have to include all the relevant fundamental and supplementary terms, etc. But there's nothing stopping you producing your own versions if you want to do so. And it may be that you want to add in sort of common additional terms that may be relevant to cooperative housing, for example. So in terms of implementation, as mentioned earlier, planning to implement on the 15th of July. The model written statements are available. They have to be given to new in respect of new contracts. That written statement has to be given within 14 days of occupation. Key point, though, as mentioned earlier, existing tenancies and licenses will automatically convert to the appropriate new contract. So if you've got a type of occupation which qualifies as a renting homes occupation contract, whether or not it's a tenancy or a license, so basically if it's a contract to occupy a property as a home in return for rent, it's likely to be an occupation contract, and it will convert and become an occupation contract on the date of implementation. So you won't have to do anything in that situation on the date of implementation. You've got 6 months to issue the written statement of that converted contract. But obviously, if you're going to be in that situation, you want to start thinking about, you know, what that converted contract is going to look like. And we've put guidance on our website to to explain how conversion happens. I'll briefly explain essentially what happens on a converted contract. I talked earlier about fundamental terms and supplementary terms and additional terms. Under conversion, it's only the fundamental terms that will overwrite terms in your existing contract. So that will be, you know, something like the antisocial behaviour term, you know, notice periods, those sorts of things, the fitness, human habitation obligation, the repairing obligation. So those fundamental terms take precedence and they will overwrite anything in the existing contract. And that is because essentially, as I said, those fundamental terms are the new legal minimums required. Anything else you've got in your contract that would either be under renting homes a supplementary term or an additional term, all of that just stays as is. And the reason for that is because supplementary terms can be varied either to benefit the contract holder or to benefit the landlord. Essentially, conversion assumes that you negotiated that term at the outset. Therefore, it's fine for that to come across into the new contract. So it's only the fundamental terms that you need to pay attention to for the purposes of conversion. So we've already laid lots of regulations around this. I mentioned there was a lot of regulations, so I'll try and explain as much as I can around these. So the fitness of human habitation regulations are there. They were laid back in January. The supplementary provisions that I talked about there, they were laid, and the model written statements that bring together the relevant terms into each type of contract. There's also explanatory information that has to be included in the written statements, and that's basically, you know, fairly straightforward stuff like, you know, this is important. You can only be evicted by a court order. Those sorts of issues. So those the relevant terms and the relevant explanatory information are all brought together in the model written statements of contract. Back in March, we laid some further regulations on prescribed forms. So that's the form that you have to use if you're going to evict the person occupying or the tenant. There may be some forms that tenants have to use. So they are prescribed in law. You have to use the relevant form for the purpose. There are some other relevant ones that, well, probably the review of decisions won't be relevant to you because that's probably more relevant to, well, it's only relevant to social landlords. Deposit schemes, if you currently have are subject to tenancy deposit scheme arrangements, or if you're currently taking deposits, that will apply under renting homes as well in the same way as it does at the moment. In fact, we're broadening the requirement under deposits. So if you currently take a deposit, but it doesn't have to be protected, it will have to be protected in future. So that may be something you need to look at. And also, we've made some regulations about what to do with any personal possessions that are left behind if the property is abandoned. We've got some further regulations that are coming out in June. They are some fairly technical amendments to those regulations there. Most of those regulations listed there about the definition of accommodation for asylum seekers and bail hostel accommodation, so not really relevant to today's discussion. There are some changes to Schedule 12, which are just some minor changes to make sure conversion happens as it should do. So nothing there to lose sleep over, if you like, but there will be some, when they come out, there will just be some things that will need to be taken account of in that converted contract that you've got 6 months to issue the contract for. Then there is going to be some regulations on something called assured agricultural occupancies and housing association secure tenancies and long tenancies. But again, I don't think those are going to be relevant to today's discussion. So as well as the regulations, there's a lot of guidance out there. So we've published lots of general guidance for landlords and tenants and fitness human habitation guidance for landlords. We've got the written contract templates that you can use, and guidance on how to convert the contract, as I mentioned earlier. And there's an easy read guide as well. And we're also going to be publishing shortly some plain language guides to the standard and the secure contracts. I do appreciate that the standard contracts and the secure contracts, they're fairly lengthy documents. Some of the language, we've tried to make them as accessible as possible. Some of it, we have to use wording that is recognised in court. So, there's words like repudiatory breach, which basically means if the landlord does something so dreadful that it's not reasonable for you to occupy the property, it enables the tenant to walk away without questions asked, basically. So we explain what some of those things mean in this plain language guide. And again, there's going to be guidance for contract holders on the fitness for human habitation. Okay, so that's the presentation. I'll close that down now and stop sharing my screen if I can find the relevant window to do that. Stop share. There we go. Okay, so I will happily hand over and pick up any questions. I know there were a couple that came through in advance, weren't there? Chair, I don't know if do you want to flag those and we'll...
Yes, there were some. Brilliant. Thank you, Simon, so much for that presentation. It's really great to hear all that and the complexities and what needs to happen next for people. There's a couple of questions came up in advance. So I know there's been some questions in the chat, so we can go to those too. One of the questions was from Teja, who's on the call now. Did you want to come in about that? You're on mute at the moment.
Okay, yeah, thanks. Yeah, so our question was to do with notice periods, but not for the co-op giving notice to a tenant, to do with the tenant giving notice to the co-op.
Right.
Yeah, so currently we have two types of co-op membership. We have provisional members and full members. And provisional members need to give 4 months notice that they're going to leave.
Right.
Full members need to give 9 months notice.
Right, okay.
So it's checking whether it's still okay that the co-op can expect, long notice periods from tenants.
Right, that will be, so the notice periods are one of those fundamental terms that I mentioned earlier in terms of, things that can be modified, but only to benefit the contract holder. So on that, on the notice, I'm just trying to find the relevant notice actually as we speak. I think it's under, so early termination, so I'm just trying to find it. So contract holder's notice is a fundamental term. It's actually Section 168 of the Act, but I can put that in the sidebar. So the contract holder can give notice, but that is a 4-week notice. Now, because it's a fundamental provision, that could only be varied one way to benefit the contract holder, which essentially means it could only be shorter than four weeks. It can't be more than 4 weeks. So that is something that would change as a result of this the implementation. On the other way round, as far as the landlord giving notice, there would be nothing to stop the cooperative increasing the notice that they need to give if they wanted to do that. Because that again would be seen as something that would benefit the contract holder. So yes, there is a change there under the new occupation.
I think, from the point of view of the co-op, it's a really big problem, this. As soon as I saw this legislation, I thought, oh no, this is really difficult, because in the 15 years of having the co-op, we've never had to give notice to anybody. But in terms of the co-op managing to work effectively, there's no way we can find a new member, within a month, because we have a lengthy process to go through. People often are moving quite a distance. It might even take 3 months once we've got somebody for them to have enough visits to the co-op for us all to be happy to live together and commit to being in close contact. It's completely different to, you know, finding anybody in a normal private tenancy. So it would leave us potentially with very long voids, which we can't afford.
How often does it happen that that someone's giving that
Usually maybe once a year somebody might be leaving, and usually it takes us between 6 to 9 months to find a new person or a new family. Like we've had a new family moving from Germany, you know, all sorts of things where it takes a long time. People selling their house.
Right. Are they occupying under a? Presumably they're not occupying under a fixed term.
No.
Because one option that is open to you would be to, if you wanted to essentially find someone in for a certain period, sort of minimum period of time, for example, you would be able to issue a fixed term, because under the fixed term, that notice does not apply. Because the contract holder is bound into the fixed term in the same way that the landlord is bound into the fixed term. So that might be something to to possibly think about. And obviously, it's not uncommon at all for in the private rented sector for renting to start off on a fixed term basis. So that might be something to think about.
So you mean we'd have to do like a rolling series of fixed terms?
You could do a rolling series of fixed terms. So I was just thinking, if you had a situation where you wanted to, if you thought the person was more likely to leave sooner, earlier on in the contract rather than later on in the contract once they were settled, etc., it would be open to you to think about a fixed term initially and then allowing it to go periodic, if you want to, but then the 4-week notice would apply.
Yeah, that's the problem for us, that the 4-week notice is just unworkable. Yeah.
At the moment, obviously, that is the under a short-haul tenancy arrangements. That is the sort of similar sort of arrangement in terms of notice period that the individual can give to leave the property. So it's not unusual in terms of other forms of renting. I'll put it that way. I appreciate the point you're raising.
Yeah.
And then did you?
Can I ask?
Sorry.
Is it a straightforward rental agreement that you have with your new members, or is there any loan stock issue involved with that?
It can be either, but for provisional members, they actually can't have loan stock in the co-op until somebody becomes a full member. So we have a whole range of people living here. So some people who are on a provisional occupancy agreement with a 4-month notice period either way. And then we have people who are full members. And so I think all the full members do have loan stock. And so full members give a 9 months notice, really because we do find it generally takes that long to find new people and for them to eventually move in. So
the expectation that the new member will bring a loan stock eventually. Yeah, but
they don't have to. Yeah.
So at the moment, what if someone didn't give that 9 months notice, let's say, and they just moved out because they didn't want to stay? What would happen in that scenario?
And they have to pay the rent for the 9 months.
And does that ever have you enforce that?
Yeah.
Right. So it may be have a think about the fixed term option, because that might be appropriate under the circumstances you've set out. But I mean, it's something probably to reflect on a bit more, isn't it? And then was there another? Sorry, there was another question. I know. Was it Sheena had a question in relation to could cooperatives have a template contract? Sheena, I don't know if are you on the line?
She's not on the call. Yeah, we could go to that in a moment. I know Christine put her hand up.
Oh, right, sorry, yes.
From Gollum, and I was just wondering whether Christine, you had a direct point related to that discussion we just had about notice periods.
Yeah, it kind of was. It unfortunately wasn't really any sort of suggestions of solutions, but I suppose it was just to kind of respond to the discussion and say, I know this is something we've discussed earlier, in that for a lot of housing cooperatives, the way in which we live together is much more like owner occupation and much less like any sort of private rental agreement. And so that's why some of these problems are coming up, where it's, you know, it's completely reasonable that a tenant might give a month's notice to move out and the landlord could find a new tenant to take that property within a month. But in the kind of ways that we're living and the kind of commitment we're looking for from new members, that's complete, as Tej said, that's completely not feasible. And so it potentially is creating like quite serious financial implications for us of having like really long voids, for example. And you know, I know we've discussed before that you're not going to suddenly make another type of tenancy for housing cooperatives, which is unfortunate for us because the implications of some of this stuff is quite significant for the way that we operate.
And that's why I wonder whether, if you wanted to have a situation where you had a 9-month fixed term, for example, that if that was there would be nothing stopping you putting in place a 9-month fixed term, because that would give security of income during that period, and it might be you think about a rolling arrangement. So there is that option, because the 1-month notice only applies in once the contract has gone periodic after a fixed term or outside of a fixed term.
But you would have the problem of at the end of the fixed term, so you're coming towards the end of it, then obviously the notice period would be increasingly short, wouldn't it, towards the end?
Well, if you would be able to put in place a if someone had said during the fixed term period that they wanted to leave after they were definitely leaving at the end of the fixed term, it would be open to you to start the process of finding a replacement. So I mean that would be possible during the fixed term period if that was the concern. So yeah, that it may be on obviously if someone was you know, committing antisocial behaviour or whatever, was in breach of the contract in some way, then you would be able to look at a breach of contract claim if you needed to get back possession under those circumstances. You don't have to wait the 6 months then, for example, from on a no fault notice if the person is at fault. So if there's an issue about some, you know, antisocial behaviour, in the same way that you could have that situation within an HMO at the moment, where you've got, you know, house in multiple occupation and one person is acting in an antisocial way, then you would be able to take action against that person on a breach of contract. And in that situation, you can actually start the court possession process on the same day as you give the notice for breach of antisocial behaviour.
I think for us though, that is so unlikely as a scenario. Like we've never had anything remotely like that kind of problem, because we go through such a long process before people come and join us. You know, we have them coming, staying here. We spend a lot of time meeting with them, and you know, it's a very long thing for somebody to actually come and be committed to living here. So our problem's entirely the other way round to the problem that most situations are going to be concerned about. You know, our problem is about the financial issues when people leave. It's not that we're trying to get rid of anybody. We've never had to do that. It's that we need to keep people for long enough to give us time to find somebody new.
Well, and that's where the fixed term approach might be the one to follow. Have a think about it. It might be you might be able to use fixed terms for that purpose.
But I think, you know, if there is any option of introducing a different kind of tenancy agreement for our situation, then that would be one of the main things that would need to be different.
It's not because what we've just talked about is what's called a fundamental term. I mean, it is something that's in the primary legislation, so it's not something that could be done in secondary legislation. It would have to go as an act back through the Senate to make a change of that sort. So if that was something that was needed, all I could say was that would be a future legislative change to take forward as primary legislation. That's obviously something which we can work with the sector, but it's not something that's going to happen overnight, I suppose, is what I could say. Is all I can say.
Yeah. Well, I suppose I'm just registering that I think that is something to consider.
Right.
Different primary legislation, because this doesn't feel like it fits our situation at all.
Right.
And it's sort of taking
Thank you.
away one of the fundamental things that fully mutual housing co-ops rely upon, really.
Right.
Yeah.
And I think that is a common situation across a number of different housing co-ops. But I'm going to bring Jacinta in because she's had a hand raising for a while. Thanks, Jacinta. Could you unmute? Sorry.
Hi. Yeah, I just wanted to support what was just being said there. But on another question, in the past, when we have provisional members, they live with us for 6 months, and at the end of that time, we decide between us all whether we want that person to stay permanently, and would then give them notice. Under the new legislation, would we then have to give them 6 months notice at that point?
Yes, if you started with a fixed term, so if you said, well, we're going to issue a 6-month fixed term, then again, if providing they're not in breach of the contract for, say, antisocial behaviour, other reasons, or rent arrears or whatever, then you would be subject to you would have to give the 6-month no fault notice, because the purpose of that is, going back to what I was saying about granting better security of tenure, is saying someone who's not at fault should have at least 6 months to find somewhere else to live. So that's the way that works.
So we would have to have someone living with us for a year, basically.
Yes, essentially that if they're not in breach of the contract. And obviously there are things that we talked earlier about additional terms that can go into the contract, and so let me give you an example that's come up within higher education institutions, just because it may be something that there's a parallel for the sector on. So they have said, what if someone ceases being we've got someone in accommodation block as a student, but they then are no longer a student, they've left the university. Do we have to give them 6 months notice? And we said, well, if you, as an additional term, if you include that they have to be registered with the university, then when they are no longer registered with the university, that would be a breach of contract. And under that breach of contract, you would be able to issue a 1-month notice, and then go, if they didn't leave after the 1 month, then you would be able to go to court to get possession based on a breach of that specific contractual term.
Could you say that they have to be actively participate in the running of the co-op?
I don't see why that couldn't be included as a contract, as an additional term, because you will have because it reflects how the co-op works.
Okay.
I can't give you legal advice, but I mean, it sounds like it's a perfectly reasonable thing to include as a term within the agreement.
Great, thank you. I also have some points on the human habitation thing.
Oh yeah.
When we, I don't know if you want to move on to that later.
We'll come back to that if we may, if that's okay. There was, I noticed in your presentation that there's prohibited conduct statement, which is an addition. Did I get that right?
Yeah, there's something called a prohibited conduct standard contract. What that is, it's something that's really only relevant to local authorities and registered social landlords. What that basically says is, instead of the default of issuing the secure contract, you can issue a prohibited conduct standard for two. So if someone is in a secure contract, in a secure with a housing association or an RSL, and they break the antisocial behaviour term, rather than going straight to eviction, the social landlord can issue a prohibited conduct standard contract, which basically enables them to get possession back with only 2 months' notice on a no-fault basis. So it's kind of saying, rather than evict you, we'll give you another chance under this contract. If you continue to misbehave, we'll be able to evict you more easily. So I don't think that particularly is going to be relevant to the cooperative sector, because I'm assuming it will probably be, well, the default contract that would apply to the sector is the standard contract, as I say, either periodic or fixed term, or maybe start fixed term and then go periodic.
Yeah, no, I was just thinking at the end of a 6th period, they could cease being members of the co-op, and as soon as they cease being members of the co-op, if they put in the standard contract, then you would be able to ask them to leave the tenancy.
Yeah, sorry, that would be the case. Yes, if you had membership of the co-op as an additional term, and they were no longer members of the co-op, then that would be something that you would be able to seek eviction for on a 1-month notice. Yeah.
Thank you. Christine, you had hand up, but you put down. I don't know if you're still there with the question.
Yeah, I kind of had a sort of overarching point, and I wonder if maybe if we're going to discuss the human habitation stuff next, maybe we should do that, and then I can kind of come back at the end, if that's okay.
Cool. Yeah, let's do that. Just into your back.
So I live in a remote off-grid housing co-op. We don't always have electricity. We don't have central heating. We have our own water supply. It's an amazing place to live and a great experience, but it probably doesn't always fit in with a conventional idea of what a landlord should provide. So some of the fit for human habitation stuff makes me a little bit nervous. And the other thing is, because we don't have electricity all the time, having wired in smoke alarms isn't really the most important thing for us. I'm just wondering if you have any comments on that.
Right. I mean, there isn't an opt-out from the hardwired smoke alarms. I mean, but so they do have to be fitted. I understand if there's a break, if there's a power cut, then there's going to be an issue. Obviously, I think the hardwired smoke alarms are generally have a battery backup, right. So that would hopefully cover any periods where the electricity's down. In terms of the general requirements on fitness, I mean, the requirements, if you have, I don't know, you may have had a look at the guidance, I don't know, but the 29 hazards, it's all about what is reasonable to occupy the property. Now, I would have thought in your situation, as you live in the properties yourselves, you are not going to want to be living in a property that is not fit for human habitation. So it would be quite surprising, I would have thought, if if you ended up in a situation where there was a challenge about whether or not the property was fit for human habitation, because it's probably more likely to arise, I would think, where the landlord is not living in the property. So I wouldn't think you should have too many concerns on that point, but at the end of the day, if it's not fit for human habitation for one person living in the property, then it's probably not fit for others as well. So I suppose it's something that would need to be looked at.
Okay, thank you.
On that point, if a member wanted to make that complaint, where would they go? Would they go to the courts?
Ultimately, it's the decision would rest with the court. In the same way, at the moment, if there's a repairing dispute, so someone was complaining that you weren't repairing, their window or whatever, then that dispute would ultimately now be settled in the court. The same applies under the fitness for human habitation requirement. If you and the occupier can't agree that something is whether or not something is fit for human habitation, there could end up, the occupier could end up making a claim to the court on that point. Again, I don't know how often you get these sorts of repairing. If you don't get many repairing obligation claims at the moment as a sector, it's probably unlikely you're going to get many fitness for human habitation claims. Going back to what I was saying earlier, you want to live in decent properties yourselves anyway, so you're probably keeping them in a good state of repair and fit.
I mean, ultimately, it's up to the members to decide at general meetings, usually general meetings, what the maintenance agenda is for a particular month or year. So it would be up to the members, who are also technically the landlords, that decide that. So I think on that basis, it is unlikely that there would be a complaint, because the members who are present would be able to bring that forward and discuss it. It's an interesting kind of scenario, and it's different to most landlord-tenant situations. Christine raised a question in the chat here about the cost of that, and that would have an impact on co-ops, specifically on the fire element. Do you happen to know, ballpark, how much that would cost for installation? And then Claire, I think, mentioned that there might be some help for that in certain circumstances, eligibility criteria.
Sorry, I missed that slightly. It was a bit crackly. Was that what the cost of installing hardwired smoke detectors is?
Exactly. Yeah.
Right. I think we've got there might be something in our fitness guidance on that. I know we did look into it as part of our impact assessment. So if it's not in the guidance, it's in the impact assessment. I'll have a look at that while we continue to talk, and if I can find it, I will drop a link in the sidebar. I don't think it's not excessive, because I think it's possible for the hard wiring to be done through the light fittings, through the lighting circuit. So I don't think it always has to be sort of, lots of channeling back to the back to the board, etc. But I'm not. Ultimately, it's going to depend on the situation in the property, I suppose. But we did do. I'll see if I can dig out the impact assessment. What was the other aspect of that question? Sorry, Chair.
So Claire was saying that there is some support for people to have safety features fitted in their homes, but there's obviously eligibility criteria around that, and it might be regional.
Yeah,
do you want to come in on that? You said South.
Yeah, some fire services offer smoke alarm installation, and we'll do a visit to people's homes as well to check what's actually needed. But there is some eligibility criteria that relates to that, but presumably someone within a housing co-op, if it's a shared living sort of situation, if someone is eligible, then hopefully the whole housing cooperative would be eligible. I've put the link for South Wales there, but presumably the services that cover Mid and West and North offer something similar as well.
And I think, I know we've put links in our fitness human habitation guidance to the fire services for information on that, on certainly on the support they can provide in themselves anyway. There should be something there. I'm just trying to find those regulations as well. I mentioned the impact assessment. Sorry, so I will try and answer any questions.
That's great, thanks, Simon. Christine's got a hand. Do you want to come in, Christine, now? Or?
Cool, yeah, thank you. I'm conscious that I've sort of had a few contributions, but I suppose I just wanted to kind of make an observation at this point, which is that at this stage in this legislation and its implementation, as housing co-ops, we're kind of increasingly aware that some of this doesn't quite fit with how we operate. And we've basically got two choices. We can either quietly just not implement new tenancies and hope no one dobs us in, and the most likely time when that might happen is if a new member comes, well, any member is disgruntled with the co-op and decides that, you know, they want to cause trouble, or even just that they actually would like better terms for them as the members, and they sort of take up with the co-op that, well, your old tenancy agreement says you need to give me 9 months notice, but actually I need to give 9 months notice to move out, but actually legally I only need to give 1, so I'm only going to give 1, and if you try and enforce the other 9, you won't be able to, because, you know, legally that's what I should be entitled to. Or the alternative is that actually we do, which I think is is what we will be doing, is, you know, we will write new tenancy agreements that meet with these requirements, but we will probably have some kind of informal conversation with new members when they join, is that, you know, yes, legally you only have to give us a month's notice to leave, but it would be really helpful for us if you could give us a bit more, because that's how, you know, it takes us a really long time to find new members, and there's a good reason for that. You know, to say, yes, legally we are required to provide homes fit for human habitation, but we know that when we bought our first home, it was not fit for human habitation. And the only way that we could make the co-op work is to basically live in a house that was in the process of being made fit for human habitation, but was not fit at the start. And say, you know, if you know, that's kind of maybe what you're signing up for, but you'll know that that's what you're signing up for, and you know, we will be working on that together. The times when that might cause trouble is you know, the classic situation of, you know, a new co-op buys a house, is, you know, it's not in a very good state. The process of doing up is, you know, stressful and disruptive, and, you know, that's the sort of situation in which, you know, conflict can arise, and you can envisage a disgruntled member, you know, having had enough and, you know, taking it with the co-op and say, well, legally you're meant to be providing me with housing fit for human habitation, and you're not doing that, and I'm going to take you to court, or, you know, I'm going to, you know, use my legal rights against you. And I think, you know, there's nothing we can do about that as co-ops. We, you know, have to hope and assume that that is going to happen very rarely. But the bottom line is that as co-ops, as co-op landlords, as well as members, we're not protected from that anymore because of this legislation. And I guess for the cooperative movement, the job for us is to say, to monitor, you know, how often is this happening? Because if this is happening a lot, or even at all, then we need to go back to Welsh Government and say, if you really want to support housing cooperatives, you need to amend this legislation for us to reflect the fact that housing cooperative landlords and members have a very different power dynamic, and you know, work in a very different way to the standard landlord-tenant response sort of relationship. And I think that's all we can really do at this stage. You know, we can't change the legislation that is now coming in, and, you know, I think all we kind of do is, you know, talk to our, you know, within our memberships about, you know, yes, this is the legal situation, and this is ideally what we would be doing, and hoping that in the main we can work with that and monitor for those, you know, problems that we're concerned that may arise.
I would just say, I think you've summed up the situation, and I think the nature of the sector of your is exactly as you say. Really, it's people getting together and working together and living together to improve the property, etc. And I'm sure in the vast majority of cases, people will continue to do that with a very positive attitude. And it should be in a small minority of cases where hopefully an issue will arise. But yeah, I think that sort of informal arrangement and discussion in advance is probably, you know, will be very helpful.
Thanks, Simon, and Christine as well for that.
I've just put some text in the sidebar, which is basically the cost for installing a unit. An installed, it's basically an interlinked alarm is £70 to £100 per unit. So that's that was the information we included in our impact assessment for that legislation.
Great, thank you. Claire and then Gwen had raised her hand. Claire?
I was wondering if an option for housing cooperatives would be to issue a rolling fixed term contract with and ask tenants partway through. So if you issued one for 12 months, for example, at 6 months, you ask the residents, the co-op members, if they're going to renew or not. If they say they're not, then the co-op can issue 6 months notice and set about finding a new member to take that place on the presumption that they're going to, that this person doesn't want to renew their contract and is intending to move out. I know it sounds a bit harsh maybe, but I'm just wondering if that's one way around some of the issues that have been raised, so that a co-op can assess their financial position if there's going to be a potential void.
I think there's an awful lot you can do through those informal discussions and informal agreements. I mean, the situation with renting homes is it's setting out the statutory, the law is the backstop here, isn't it? I suppose that's the position. I get that it's not, the backstop is not favourable in a certain, in respect of that notice period to leave, but there's nothing at all stopping, informal doing things by agreement. I always say to landlords, there's an awful lot that you can do, probably do at the moment by agreement without needing to go to court and issue notices. You can continue to do that entirely as you are under the new arrangements.
Do you want to come in?
Oh, Gwen, did you?
Can I? Gwen had a question for a while. Thanks, teacher. Could you unmute?
Yeah, I live in the same housing co-op as Taja. I've been here just a few years. It took me a very long time. I just suppose what concerns me is that there's, I respect very much what Christine said, and I agree with her to an extent, but there's a fundamental thing that's happened, which is the law has been created without concern, respect or understanding to this sector. And I just want to say that I was involved in the recent applicants coming here in the application and admission process of new tenants here, and we had 38 requests for a small living unit just in our very small little housing co-op. It was huge. The interest is huge, and the interest is, when you listen to things that are going on in the English sector as well, it's an increasingly popular way of living. And the fact that that hasn't been understood by Welsh Government, to me, it means that we'll make agreements and we might be able to work around it. But actually, we do need the law to underpin what we're doing, actually, because it creates safety in a housing sector that's very important.
I suppose all I can say is I understand the point. All I can say is when we brought forward the legislation back in 2016 and before that, we did have a very broad ranging stakeholder group that included representation from all sectors, and we consulted widely, and that's been the basis of the way in which we've worked with all partners really in developing the legislation. So, and in fact, there was something we did under the Housing Wales Act in 2014, which was specifically in response to a request from the cooperative sector, which was to remove the block on co-ops issuing a short hold tenancy. So we did change the Housing Act 88 to allow cooperatives to issue ASTs, and involves the sector in the discussions that came forward in the Act. Clearly, this is, an issue has surfaced late on in the day, I suppose, in respect of this giving of the notice. But that is the situation that we're now in. But we've always endeavoured to work as closely with the sector as we can on implementation and indeed policy development.
I feel that,
Tej, do you want to come back in?
is that okay? Yeah. I think, you know, in terms of private landlords, this legislation's great in terms of protecting tenants. I think housing co-ops, in a way, we're trying to protect tenants even more in various ways, you know, to make it an even better situation than having a private landlord. But as Gwen says, basically, we actually need different legislation. And so I can't see how one act can actually cover all the different types of issue, really. That there isn't a one size fits all here. And I'm particularly concerned, really, for the potential for new co-ops setting up, because it would be really hard for a co-op to start trying to kind of follow these rules and at the same time find people and not end up with huge voids at a time when you really can't afford that.
Yeah, Christine's made a point there about the representation. I mean, I wasn't, and I don't think any of the team here were working in this particular department or area of work back in 2016. So we don't know what the history was of that representation and who did that. But Simon has engaged with us through this process, and it's been really good to have those kind of conversations. And it's difficult because he's doing that over a wide range of different interest groups. But yeah, I think in the future we can. Jackie's got a point, but she's going. Just to say that we'll try and refine that engaged process in the future, and yeah, so we can feed this feedback at an earlier stage. It is difficult because what Simon and Welsh Government are trying to do is cover a multitude of different kind of landlord scenarios and do it in a way that covers as many people as possible and protects tenants. As you said, Tej, it's a difficult situation, but I do agree that co-op, one of the beautiful things about co-ops is that they have flexibility because the membership decides what rules are beyond the kind of model rules that everybody accepts when they register as a co-op. And some of that is around kind of designing in that flexibility about when people leave. The other question that we had from in advance was around coming up with a kind of model tenancy that people could add to. And I don't know whether you have any thoughts finally, Simon, on that, or whether that's something that would work for this sector.
Well, I would think it should be possible to take we on the website, we've got 2 model contracts. One is the model contract for the periodic standard contract, and the other is the model for the fixed term standard contract. I'll put the link in the sidebar in a minute, but essentially those contracts will bring everything together. But as I say, I think there may be something that Compass can do in terms of maybe having if there are a standard set of additional terms that you think would work for the sector, you might want to add those into the model contract, and then that could be shared to your members. But that's something which you would have a look at it, and obviously happy to be involved in discussions around that. But the decision as to what terms might go in would ultimately be one for sort of Compass and your members. But I'll put a link to the model written statements now so that you've got those to hand.
Just worth saying that, yeah, go on.
Oh, just back to Claire's suggestion about the fixed term contract, and maybe people, say you had a 12 months fixed term contract, but then every 6 months you start a new 12-month fixed term contract. So if we did something like that, could you just check out that would really be okay, and we can do that? That might be something that needs checking out.
it's an innovative solution which I need to think a bit more about. But it's a possibility that you're simply you're starting and you're ending one fixed term and moving on to another. Yeah, possibly that could work. Well, I think the legislation would allow for that. You would be able to agree with them a new fixed term contract and end the previous fixed term contract. I mean, that would be a possibility, I suppose. There may well be some innovative solutions to look at, which is why I'm happy to carry on talking with the sector, to see if there's a way through some of this. I put a link in the sidebar to the model written statement, so you can have a look at that. They don't include, obviously the additional terms aren't there because those are things that you were too straight in. Another additional term would be something like a PETS clause, by the way. I mean, anything like that you're going to have that would be standard. That would be a good example of an additional term. But there's probably, as you were suggesting earlier, specific things to managing co-ops which would be relevant to include as well.
Thank you, Simon. Christine, you've also been doing a lot of work on this with Colin Housing Co-op in Swansea, in terms of like looking at your contracts, how they apply, your tenancy agreements, and how they might change over. And I think we're going to kind of meet up, aren't we, Casey and yourself, and maybe we were hoping to have somebody from Wrigley's solicitors on the call today, and they did book on. But we'll follow up with them and send them this recording and see some work that we can. Okay, Simon, you've got to go. Thank you.
No, I'm sorry. Yeah, sorry. I've got another meeting that started at 1:30, which I'm afraid I need to get off to. But I'm very happy to continue discussing.
Thanks so much for. Brilliant. Thanks so much for coming and catching up.
You've got the
take care.
Okay, thanks very much. Bye bye.
Thank you.
Bye. Thanks. Bye bye.
Thank you. Yeah, I can forward the presentation to everybody as well. I'll do that afterwards. And the recording when we.
That'd be really helpful. Thank you.
Christine, do you want to come back on the? Yeah, we'll try and set up a meeting.
Yeah, so I've been being defeated by my spam filter the last few weeks. So I found all these messages from you and Casey in my spam folder this week from like the last month. So apologies about that.
No problem. I think that's happening to a few people because of our name change.
Right, yeah,
not recognising Compass.
Yeah, got you. I was just going to say this is kind of top of my to-do list at the moment, because we may have a new member moving in July, and if they move in after the 15th, we're going to have to give them a new tenancy agreement. So we've got a bit of a deadline. Yeah, so I think my job is to go through the model tenancies that Simon's just shared the link with, and our current tenancy, and see if I can kind of mash them together essentially. And probably where they don't match up is kind of putting in basically the voluntary stuff of like, well, ideally we'd like 6 months notice of you moving out, but actually legally you only have to give us one. Not quite worded like that, but essentially flagging up where we'd sort of suggest that voluntarily tenant members go over and above the legal requirements for the benefit of the co-op, but also outlining what their legal kind of rights are as members. I think that's the best we can do really at this stage.
Tej and Gwen, are you signed up as clients of ours?
Yeah, I think
yeah,
so.
they are. Sorry.
They are.
Yeah. It's
Brilliant. Good. So
I might be saying that wrong.
Yeah,
that's great. So
I had some contact with Claire a bit back about various things, and then we've had more correspondence recently about retrofit. So there is a bit of back and forth.
Ah, yes. The heat pumps. Is that right?
We do have heat pumps already. Yeah.
And you were looking at retrofitting to improve insulation and so on, so that heat pump is working better for you. Yeah. Okay.
That's something that I wanted to mention to everybody, is that we've put in for funding for a small pot to do 15 energy assessments. And thanks, Christine. I'll catch up with you later. On different housing co-ops in Wales. And we were, unfortunately, we won't know about that funding until November. We will get back in touch with you about that, and if we get it, then we'll be able to send like a qualified energy assessor to different co-ops to talk to them about what they've done in the past, how that's worked for them, what they need to do in the future. The long-term goal behind that is to there's a program called Optimise Retrofit, which at the moment just extends to housing associations, and we want to get that extended to housing co-ops, and Optimise Retrofit themselves are quite keen on doing that. It's just the Welsh Government at the moment confines the legislation to just one housing associations. So trying to get them to extend that to housing co-ops. And what that programme does is that it's quite substantial retrofit, capital funding for retrofit. But that is probably going to be like a year away or so if we do get that at the moment. We'll be in the loop about it. And I totally get where you're coming from on this. This is a big problem for you with the situation with the 1 month. I hadn't totally appreciated that in the legislation before. Yeah. I used to live in Machynlleth Housing Co-op, and we had similar issues in terms of the length of time it took to replace people, because obviously all the members have to agree, and you want to get the right person, because having the wrong person means disruption and and potentially inflicting another.
We'll have to. I mean, luckily enough, I think we're quite settled at the moment as a group, but like Tay just said, everything can change quite quickly, and we're so small that we can't withstand that. And I think the longer you are here, it takes time to be here to understand the legacy of the work that people have put in the past to make it resilient enough as it is at the moment. So something like this just makes it feel precarious, really. Which is just feels like we should really, given the wobbly world that we live in and the level of interest that there is in how we're living, it just feels like it's an obstacle when really we should be having props. I really feel that we really need props. And sorry to go on. I don't feel like it's the fault of individuals. I didn't want to make people feel defensive, but yeah, it takes quite a lot to, if you've lived in a co-op, you know what it's like to live in it. So it takes a bit of a shift in yourself to live in it anyway. So then to find that there's legislative things changing to make it more difficult is a bit frustrating. So sorry. I felt
you don't need to apologise at all. Yeah. Thank you. I'm going to stop the recording now. So